Hi, I'm here today with Jay Heimes. Jay is the co-chair of the Antitrust and Competition Litigation Practice at Labaton, and he's also serving as a court-appointed monitoring trustee with the Department of Justice's Bizarre Voice divestiture. Previously, Jay served as the Antitrust Bureau Chief at the New York Attorney General's office, where he led high-profile antitrust investigations and enforcement actions. So Jay, the U.S. Supreme Court recently issued an important ruling in the North Carolina Board of Dental Examiners versus FTC, where it held that the licensing board does not have antitrust immunity based on the state action doctrine. What do you think are the implications of that ruling?
First of all, hi Sally,
Hi.
nice to be here. A very important ruling. I think that occupational licensing boards and the restrictions that they create are an enormous drag on the economy. They are really mechanisms to limit entry and to make practice of a whole variety of professions, and not even occupations that don't even rise to the level of professions, florists, you name it, restricted. And the decision that declines to apply state action immunity to every one of these boards simply because a state proclaims it to be a state agency and then turns it over to occupation members as the legislating or regulating body is really a good decision, because now you'll have to, if you want state action immunity, there'll have to be some serious active oversight. The professions and occupations won't just be regulating each other.
So in that case, the dental board was limiting who could do dental whitening, correct?
Correct.
And so that's kind of often what these state licensing boards do, is limit who can practice certain parts of the profession?
Sure. I mean, that was a clear barrier to ease of entry by non-dentist individuals. If the board really thought that these individuals were engaged in the unauthorized practice of dentistry, they had recourse. They had access to a court system by which they could have tried to prove that claim. Instead, they engaged in self-action, self-help, and issued cease and desist letters to these dental whitener individuals. And these are not people that are going to go run and get a lawyer to defend themselves against that sort of thing. They're going to go find something else to do where they don't get harassed, basically. So there was a mechanism available. They didn't avail themselves of it. And to see the Supreme Court say that the antitrust laws apply there does not strike me as either bad or shocking.
And do you think that the federal agencies are going to move forward and kind of trying to get rid of some of the other antitrust exemptions or immunities that are out there?
Well, the DOJ won't, but certainly the FTC has had a long-standing mission or objective to look very closely at antitrust immunities and exemptions, at least particularly in this area of licensing boards and Noah Pennington. I think the commission's had a series of favorable enforcement actions and court decisions in those areas. I think there are a number of, there are lots of immunities. There are immunities for the shipping industry. Do I think the FTC is going to go after the shipping industry? Well, you haven't seen that. They certainly did go after, of course, like the trucking industry and the rate bureaus and things like that. And that's part of the FTC's mission. I think they'll continue it, and they've been successful at it.
So another interesting recent development in antitrust is the New York Attorney General's suit against Actavis over the drug Namenda. Could you talk a little bit about that case and how you think it's going to play out? I know it just had an oral argument this week.
Yeah, I think that's just a wonderful test case, because the notion of product hopping and using the patent system in a way that basically allows brand name manufacturers to extend patent exclusivity through modest, even trivial improvements in drug formulations, compounds, whatever you want to call them, is a really serious public issue. And thus far, the FTC hasn't brought one of these product hopping cases. And the New York AG brought one for Namenda. I mean, the difference is how many extended release of the tablet versus less extended relief of the tablet for Alzheimer patients who are getting cared for by caregivers that are sitting there with little cups, and it doesn't really matter whether they put a pill in the cup once a day or twice a day. They're getting 20 other drugs as well. So, I mean, the extended release version is probably, it's therapeutically identical. It's a trivial change. The documents showed pretty compellingly that the only reason that activists or its Forest subsidiary made the change was to keep out generic competition. And I mean, the judge in the district court, after an extended evidentiary hearing, effectively a trial over several days with multiple witnesses, lots of documents, issued a 100-page opinion. It's up in the Court of Appeals. His fact findings, will get great deference. He's a well-respected district judge, well thought out opinion here in particular. I think it's an important case. I will go out on a limb and say I think they'll win it in the Second Circuit. You can come back in 3 months or so and see if I'm right or not, but that's my prediction for you.
And if they do win it, do you think it'll affect pharmaceutical practices in a significant way?
I hope so. Do I, how much can you wish for? They'll still do it. Look, I mean, there are enormous amounts of drug sales involved here. You're talking about drugs that are often selling $1 billion or $2 billion a year. So the prospect of maintaining exclusivity and avoiding generic competition is a very, very strong incentive to do this sort of thing. I mean, the industry calls it life cycle management. It's not new in the sense that it's been going on for years. I wrote a paper about it back at the time that I was in the AG's office with one of your then junior bureau members, and we were encouraging the states to look at a then pending case, which they did eventually get into. We were arguing that there's sort of pseudo-innovation that is really predatory or exclusionary, and that the antitrust laws apply to that kind of conduct. I think that's the lesson of the district court's opinion here. I think that's sound as a matter of antitrust law. They've got the facts in Namenda, and I think there will be other cases that will have equally compelling facts.
So it's encouraging that that the state AG, New York State AG, is bringing kind of a new test case. And do you think that the states are actually more aggressive or perhaps less risk averse to losing antitrust cases than the federal agencies?
No, definitely not. I think, look, the DOJ doesn't bring a lot of test cases. That's true. But mostly they're prosecuting cartels, and occasionally they may still find a Section 2 case. And they're doing merger reviews and they're litigating merger cases. They're not bringing a lot of test cases. The FTC will bring test cases, and they have. And look, I mean, they got the activist case up in the United States Supreme Court eventually because they needed to test the antitrust standards for reverse payment settlements. So the FTC is certainly willing to bring test cases. They haven't found a good product hopping case. I assume that's why they haven't brought one. But I don't think the states are less risk averse than the FTC. The states are very conscious of health care, and they're very conscious of the expense to the individual citizenry, and they bring a lot of healthcare cases. They're not generally, however, cutting-edge cases. This happens to be one of those, and look, New York should be commended for bringing that kind of case. There's probably not a huge amount of money right now in that case. But if generic competition is actually driven out, then that's a big impact.
And you just mentioned the FTC's case against Actavis. What has been the effect of that decision?
It's sort of changed the focus of the litigation. I think the focuses right now of the litigation are, number one, does the decision apply to non-cash settlements? And there are a number of those cases kicking around in the lower courts, and the courts have gone both ways on that. And that particular issue is up on appeal in the Third Circuit. I think that because that continues to be an open issue, that attorneys for brand name companies are continuing to look for ways to settle these kinds of patent infringement cases so that it is more difficult to characterize the case as a, quote, reverse payment case. And they've been, that's been an ongoing tactic as well for years, but given the fact that now you have some kind of rule of reason analysis, whereas previously these settlements were basically presumptively legal with a few exclusions that existed under the Court of Appeals law. Now you've got to be more creative and try to figure out ways, I hate to say this, but to mask what you're really doing, which is splitting the monopoly rents, and there's nothing more complicated going on there than that. However you try to dress it up with, cross licenses, distribution agreements, no authorized generic provisions, all that stuff is really a mask to conceal the split of the monopoly rents. That's the economic reality of these situations. They recur. And so the Brand Name Manufacturers Council will be more creative.
So just for our readers, the background is we're talking about the reverse payment, that the case was about reverse payments. So you're saying that they're just going to be more creative in terms of finding ways to pay the generic companies to stay off the market. The branded manufacturers will be more creative in finding ways to pay
Sure,
them.
you've got this perverse dynamic, which is that the company with all of the great valuable patent rights, which it says are being infringed, winds up paying off a generic to avoid having its rights challenged and presumably invalidated. And that's just a perverse situation, but they're doing it because the monopoly profits from brand name drugs are so huge that cutting off a chunk of them and giving it to the generic can in some instances be more money than the generic would ever make by entering. That's what it's about. And there are hundreds of millions of dollars in value that changes hands through that process.
So moving on to a different topic, there's been a lot of talk recently about antitrust enforcement over U.S. tech companies by the European antitrust regulators, and just recently they announced that they were going to bring suit against Google, that the EU is going to bring suit against Google. Since you were the head of the New York AG's Antitrust Bureau and you would be looking at cases like this, if this alleged conduct was before you, would this be something that you would be interested in, a case you would be interested in pursuing?
As I understand it, and I haven't followed a lot of what Europe has been doing on Google, but as I understand it, the issues here are favoritism of their own search results over those of competitors. And you've got all kinds of concepts of sort of new entry into search and specialized searches for travel, for hotels, for automobiles. And Google is, of course, this global search engine that works its magic and then starts to rank the results. And the question is, are the results, actually fair and impartial results? And the Europeans have charged that they aren't. I don't know the facts underlying that. It seems to me if there is a bias in the search engine that is favoring Google, that is effectively an entry barrier, and it's effectively a way to raise rivals' costs in entering into these online search areas. I think that's worthy of investigation. The FTC kind of bowed out of it. It's not easy by any means because how that search engine works is going to be a very difficult thing to get a handle on. The actual effects of what it produces ought to be, more identifiable and objectively verifiable. The remedy is very, very challenging. I was sort of surprised to read the news reports coming out of the Commission's announced statement of objections that the idea is to come up with a remedy that's future-proof and not one that drills into the algorithm. I hope they're right on that score. I think it may be a little naive to think that somehow you can come up with a remedy that doesn't take account of what's producing the results.
And
I should go back. Your question was, would the states be interested? It's a neat case. Yeah. It would require a significant amount of resources. It obviously would probably not be a high-dollar case for a state, and therefore would require a good bit of selling within a state AG's office, because let's face it, the state AG's offices like to actually find dollar cases that return money to individual consumers more than they like equitable relief cases. The FTC is more suited for that sort of case. But look, the states brought the Microsoft case, and there was no money in it at the time, but it was an important case to shape the direction of technology. So, could you perhaps sell a case like this? Perhaps.
All right, well, thank you so much for your time today, Jay. It's been a pleasure, and let's do this again sometime soon.
Thank you, Sally. Nice to see you again.